Major breaking news and a big win for President Donald Trump and Republicans everywhere, in particular in the state of Texas, as the Supreme Court, specifically Supreme Court Justice Samuel Alito, has stepped in and shut down, at least for the moment, that insane preliminary injunction down there in Texas by that 3-judge panel, 2-1 decision over a Jerry Smith dissent, that basically said that Texas had to go back and use the 2021 map that favored the Democratic Party. Well, Justice Alito just stepped in and has put a pause on that insane lower court ruling. Let's break down the details when we come right back. But the bottom line is another big win for the Trump administration, the Trump agenda, and Make America Great Again, and more. Let's talk about it. Hey folks, I'm Mark Smith, host of the 4 Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, before we break down this exciting news out of the United States Supreme Court, I just want to let you all know I've just received notification, and thank you all for what I'm about to say. I've just received notification from the Gundies Awards that I've been nominated for the top voice of the Second Amendment again this year. So we'll be talking more about that coming forward. The voting starts on December 1st. I think it runs for 2 to 3 weeks, but I'll give you more details. But again, I'm honored that I've been nominated for the 2026 Gundies Award for Top Voice of the Second Amendment. I really appreciate your support, and I am honored by that nomination. All right, with that said, folks, we have another big win for the Trump administration and the Trump agenda. Every day there is a fight. Every day all across America, in courtrooms, in political battles, and in every state house, there is a fight for America. Well, we do have a big one out of the Supreme Court. Justice Sam Alito has just entered an order, as you know, freezing the ball, staying that lower court decision from a 3-judge panel that said that Texas had to use for this upcoming House of Representatives races in Texas the redistricting maps from 2021, and that the state of Texas was not permitted to use the redistricting maps from 2025 that had just been redrawn in favor of the Republicans, hopefully to add 5 additional Republican seats in the House of Representatives from Texas alone. As you may recall, that 3-judge panel came out and said that this redistricting process violated the Voting Rights Act because allegedly it violated race discrimination laws, claiming that this was not motivated by pure politics. It was motivated by race discrimination. That's right. It was an absurd assertion. And yet in a 2-1 decision, 2 district court judges found that the state of Texas did indeed, in redrawing these maps in 2025, they were motivated by race discrimination, as opposed to the obvious motivation, which is that President Donald J. Trump called up and said, hey, Greg Abbott, hey, Texas legislators, you need to redistrict so we can keep the House of Representatives because I don't want to get impeached 1,000 times by nutjob crazy Democrats that want to advance the progressive agenda, have no interest in advancing traditional American values. So with that said, the 3-judge panel found there was race discrimination, and that the maps from the congressional districts that were used in 2021 to allocate the 40-some-odd House seats among the state of Texas for those members of the House of Representatives to represent the state of Texas in Washington, D.C. in the U.S. Capitol, those lines were redrawn in a way favorable to the Republicans for the 2026 midterm election. They were just redrawn. You may recall there was a delay in their redrawing because a whole bunch of Democrats ran out of the state to prevent the Republicans, or the Texas legislature of Republicans, from getting quorum needed to pass these laws. There was a long delay in enacting this 2026 congressional map in Texas because the Democrats escaped the state and hid in Illinois. Nevertheless, eventually they did come back and the state passed this law. The legislature passed the law, redrawing all the maps in the state of Texas in a way that was favorable to the Republicans. So Justice Sam Alito has just entered an order specifically saying that that lower court crazy decision in favor of the plaintiffs that were suing to shut down this redistricting effort would be stayed. Here's what Justice Alito had to say in his order late Friday night. Justice Alito wrote, quote, upon consideration of the application of counsel for applicants, It is ordered that the November 18th, 2025 order of the United States District Court for the Western District of Texas is hereby administratively stayed pending further order of the undersigned or the Supreme Court. That's right, folks. Justice Samuelio has just put a pause on that, which is a very good sign. If I were the state of Texas, I'd be very happy with that outcome. It's an indication that the Supreme Court is going to rule in their favor. Keep in mind that the clock is ticking, 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 ticking. Just to put this into perspective, as we sit here right now, candidates have already declared, some candidates have already declared to run in these 40 some odd or whatever it is, number of House seats in Texas, drawn according to that 2025 map to be used in 2026. If the lower court ruling prevails, what that means is that the maps and the congressional districts that are currently being fought over in the primary process with people applying to run, that will be entirely changed. The district court, the district maps for these congressional districts will go back to the drawing that was used in 2021. In the last election, drawn in 2021, used in the last election. So right now, candidates don't know which House seats are even available, what are the districts and what are they drawn as. So you can't really figure out, can I win that district or not? In fact, there apparently is the case that several Democrats who had decided not to run for re-election because they figured they could not win in a new district have just announced, in light of the fact that this lower court ruling has said that the 2021 base maps have to be deployed and used this term for the 2026 election, that a whole bunch of these Democrats that basically said, I'm going to resign, I'm not going to run again, have now said, well, if the old maps are going to continue, then I'm going to run. So it's total chaos down there in Texas. This is a very big deal because there is a doctrine at the Supreme Court level dealing with injunctions and elections called the Purcell Doctrine. The Purcell Doctrine, named after a Supreme Court case of Purcell, basically says that even if there is truly something unlawful going on in a state, if changing the election laws mid-election would cause total chaos in that state for that election, then under the Purcell Doctrine, a federal court lacks the authority to make that change mid-election. The idea being that not only do candidates need to know are they going to run or not for what seats and who are their constituents going to be, but also the state has to prepare ballots and prepare for these elections. And these elections, for example, the midterm election in 2026, the process has already begun. So people are declaring their candidacies for various districts, and then there's going to be a primary sometime, I think, in January. And then, of course, there's going to be an ongoing election with culminating in the November 2026 midterm elections. This whole process, including the state administering these laws and these elections, has already begun. So the fact that this court, this three-judge panel in a 2-1 decision over the dissent, of course, of Judge Jerry Smith, a judge on the U.S. Court of Appeals for the Fifth Circuit down there in Texas, over his dissent. But the fact that these judges came out and said that the maps have to go back to the 2001 maps has caused utter chaos in the state of Texas. Because now people don't know what the districts are look like. They don't know what the maps are going to be. They can't send out the ballots. So the administrators of these elections don't know how to handle this, what to do. Everyone is basically frozen. And under the Purcell Doctrine of the U.S. Supreme Court, federal courts such as this three-judge panel down there in Texas were not supposed to enter this kind of injunctive relief. Nevertheless, there is a powerful brief submitted by the state of Texas arguing that the plaintiffs should lose and had not satisfied their burden for various reasons. One of which is they point out there's literally no direct evidence of race discrimination. They can't find people being quoted that's saying that they want to change the maps in 2025 for the benefit of the 2026 midterms because they don't like African Americans or they don't like Hispanics, or there's no direct evidence of race discrimination. There's none, which makes a lot of sense because obviously Texas decided to redraw all these congressional maps at the urging of President Donald Trump, who is asking them to do it because he wants to maintain the Republican majority in the House of Representatives and wants to add more seats in Texas to help him do it. That's a purely political partisan maneuver. That is a purely political partisan intent and motive, having absolutely nothing to do with race discrimination. And because the entire premise of the plaintiff's case here trying to shut down this new map in Texas was race discrimination under the Federal Voting Rights Act, they've got to show that it was race. It's all about race. And they can't do that because the Supreme Court has repeatedly said in these voting rights cases that it's up to the plaintiff that's trying to win the lawsuit. It's up to the plaintiff that's sued and is trying to get injunctive relief. It's up to the plaintiff to demonstrate that the predominantly motivating factor was race over politics. And if there's any doubt or ambiguity about the motive between, is it about race discrimination or political partisanship, the tie, if you will, goes to political partisanship, and there is no violation of the Voting Rights Act, which means a federal judge cannot come in and allow to enjoin the redrawing of the maps by the state legislature. But again, there is black letter law in the Fifth Circuit Court of Appeals that says that if a legislature is redrawing congressional map lines in the midterms, meaning between the two Census Bureau, between the two census allocations of electoral votes and House members, it is strongly presumed, if not guaranteed or dispositive, that the motive for that mid-decade change in the map is partisan politics, which is perfectly legal. You're allowed to discriminate in drawing maps against Democrats. You're allowed to discriminate in drawing maps against Republicans. There's nothing in the Constitution or the 14th Amendment that says you cannot do that. There's nothing in the Voting Rights Act that says you cannot discriminate based on political party. What you're not allowed to do under the 14th Amendment Equal Protection Clause, and what you're not allowed to do under the Voting Rights Act, is discriminate on the basis of someone's immutable characteristic of race. That is verboten. That is no-go zone. We know that. Everyone knows that. And of course, the plaintiffs here are arguing this is all about race, but of course, it really was about politics. But beyond that, the brief that was arguing that the district court judges in that 2-1 decision got it wrong points out that not only is there no direct evidence that the Texas legislature was being motivated here or incentivized or intending to discriminate on the basis of race down there when they redrew all these congressional maps, that they only have circumstantial evidence, and it's simply not persuasive because, again, all the evidence points to this is all about trying to get additional House seats for the Republicans to make sure that Donald Trump doesn't lose the House, the Republicans don't lose the House, the Make America Great Again movement doesn't lose the House. Because if the Democrats take over the House of Representatives by winning the midterms in 2026, they will shut down the Trump agenda and they will go out and impeach Donald Trump and basically conduct all these investigations of the Trump administration and basically grind his administration to a halt. That'll be the end of all sorts of good things, of course. On the positive note, as a side note, that is not going to impact the ability to continue to get good judges on the federal bench, provided that the Republicans maintain their control of the Senate, which I think they will. So in terms of federal judges that are originalists and respect the Second Amendment, I think that pipeline will continue no matter what happens in the House in 2026 for obvious reasons, that the House has no say into who becomes or is confirmed as a federal judge right now. Just for the purposes of completeness, here's what the state of Texas had to say about why the alleged circumstantial evidence that the plaintiffs had come up with was simply unsatisfactory or insufficient to win the case for them, and certainly not enough to get them an injunctive relief that would allow them to force a court or get a court to deploy the 2021 congressional map as opposed to the recently drawn 2025 map for the 2026 midterms. Here's what the state of Texas had to argue. Because plaintiffs lack direct evidence of discriminatory intent, they are left to rely on circumstantial evidence. A circumstantial evidence only case is especially difficult when the state raises a partisan gerrymandering defense. A plaintiff therefore must disentangle race from politics. Plaintiffs have failed to do this and are thus unlikely to succeed on the merits. The court must take an adverse inference against plaintiffs who do not provide a substitute map that shows how the state could have achieved its legitimate political objectives in a challenged district while producing significantly greater racial balance. If either politics or race could explain a district's contours, the plaintiff has not cleared its bar, and here plaintiffs have simply not cleared it here. I think that makes a lot of sense. Again, this is clearly being motivated by pure partisan politics, perfectly legal activity, and the idea that the plaintiffs could persuade two judges down there in Texas to rule against the state of Texas and this Texas legislature is just simply insane in my view. And the best evidence it's insane and all the way it's broken down as to why it's insane is best illustrated by that 104 page dissent by Judge Jerry Smith that points out all the insanity and craziness and illogic of the opinion of those two judges in the majority. But I'm happy to report the great news, which is as of now, Justice Sam Alito has ridden to the rescue and shut down that crazy injunction for the moment. We will get a final decision on that, I'm sure, in the next couple of weeks. But the fact that he has shut this down for now, and the fact that the Purcell doctrine says that you're not supposed to, as a federal court, get involved and bollocks up the process of an election in the middle of an election, I think there's an excellent chance that the Texas legislature is going to win this one in the Supreme Court with speed, and that attempt to upend the 2025 new map of the state of Texas for congressional races, I think that new map will indeed be the map that is used in the 2026 midterms in less than a year out from today. All right, folks, hope you enjoyed today's episode. Make sure you follow me on X at @4boxes. Don't forget to subscribe to YouTube and to Rumble, and I'll talk to you again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.